Good evening, everyone. Tonight, we'll be looking at accident at the workplace. If this is the first time that you've joined us, we do this program every Tuesday from 9 p.m. In English, and then on Thursday, we do it in Twi. Now, tonight I'm going to look at how you can be successful in your accident claim, or if you were injured because of accident at the workplace, what are the remedies that you are entitled to? So tonight I'm going to take my time to explain to viewers and also guide viewers in advising them on how to maintain record keeping to the extent that this goes to the heart of their claim. And therefore, whenever there's an accident, obviously, employers are meant to keep records. But employees also, for the purpose of ensuring that their claims are not dismissed, they are also required to keep records. So tonight, I'm going to look at remedies that you're entitled to whenever you sustain injuries at the workplace. So I'm going to take my time to look at, as I've said, three areas: the record keeping aspect of it, what you are likely to be entitled to if you ever had an accident at the workplace, whether you're an employee, self-employed, a worker, who you should report to. And I'll also be looking at personal injury claims that these claimants are entitled to. And I'll go further to look at the time limit, the limitation period for those claims to be brought so that they will not be out of time. So tonight I'm going to take my time to discuss these four areas. As I always say that most times when we are here and discussing these topical areas of the law, is because some people have become victims. And therefore, CITI law sources, we are here to conscientize the public as part of our corporate social responsibility to make people know their rights, so they will be able to accept those rights in times of troubles. So tonight is one of the days that we are going to give this free legal advice to you on how you can be successful in your claim if you were injured because of accident at the workplace. And as I do always, I'm going to open the phone lines at the end of the program to make sure that people can ask questions. And I'll also be giving updates of various areas of the law. This is where you get your updates of the law. This is where you learn about your consumer right. This is the only platform where you learn about your right as an employee. This is the only platform that you learn about how to progress your claim, whether you are making personal injury claim, and the kind of things that you need to be aware of. So if you have just joined me, I want you to obviously share the video and invite your friends and family members as I get this topic off the ground. And I'm sure that by the end of this program, a lot of you will benefit from this advice, because you will be aware what records you should keep when accident occurs at the workplace, and the time period that you have to bring your claim if you ever want to bring a claim against the employer, and the benefits or the remedies you're entitled to. This is what I'm going to discuss tonight. So I'm going to have a very short break whilst I give viewers the opportunity to get themselves ready I'm prepared for the topic, and I'm going to take my time to ensure that everyone who is watching tonight understands every single area of this particular personal injury law that I'm going to discuss tonight. There are stuff that are happening every day in our workplaces, or whenever we go to offices, on the shop floors. We do have rights to claims when these accidents occur, either at the shop floor. But tonight I'm going to deal with the accident at the workplace. But notwithstanding, people who may have questions if they have had accidents on the shop floor, at public places, recreational centers, you are equally welcome to ask questions. So in the next 2 minutes, I will start the topic, and I hope that you stay with me whilst I go for this short commercial break. thank you for your patience. As I've said, tonight I'm looking at accidents at the workplace. So I'm going to take my time to look at all the areas that viewers should be able to know in order to know their rights at the workplace. Now, when we say accident at the workplace, what we are looking at is people go to the workplace. And there are various people that go to the workplace. There are those who are employed by the employer. There are those who are sent there by agencies. So they are workers. So we have employees and we have workers. There are those who are also sent there to work on contractual basis. So they could be self-employed. So when people get to those premises to work, whether they are employed, whether they are self-employed, whether they be sent there by agencies and therefore they are workers, they have a right not to be injured at the workplace. And this is common law duty imposed on the employer to ensure that these employees don't get injured. So every employer has a common law duty to ensure that whether that person is a lawful visitor, whether that person is there as a self-employed person who is performing a contract, or whether that person is there as a worker who have been sent there by an agency, or whether that person is employed by that employer and therefore an employee, they have rights not to be injured at the workplace. And therefore, if there is an accident at the workplace, then two things need to be considered. And those two things will be whether or not that accident is as a result of the negligence of the employer. Now, so when we are looking at the negligence, in this case, we are looking at breach of duty of care, because employers have a duty of care to the staff, the employees, the workers, the self-employed, including lawful visitors on the premises, not to be injured. In most cases, accidents do occur at the workplace. So if those accidents do occur, then one needs to look into whether or not that accident was as a result of the breach of duty of care by the employer. And as I always say, that breach of duty of care could even be as a result of another employee causing the injury of the other employee. In this case, as I always say, that employer is vicariously liable for the act of an employee who causes an injury to another employee. So the employer has various duties to everyone who is on the workplace or on the premises at the time. And I'm sure that it's not in dispute that people here, oh, if you ever had an accident at the workplace and it's not your fault, then you could be entitled to compensation. So this is something that is known to a lot of people. People are aware that when they get accident at the workplace or when they are injured because of accident at the workplace, they are lawfully entitled to compensation, or to be specific, financial compensation for their injuries. But tonight, I'm going to look at how you are going to be successful in that particular claim. Because most times, people have had accidents, and I'm sure most of you watching me may have had family members who have been in that situation, or you may have even been in that situation yourself, or may have heard it from someone. That most times, even though employers have liability insurance covering some of these mishaps or accidents at the workplace, they do pay a premium. And the more accidents at the workplace, the more premium they are likely to pay. And therefore, they will be doing everything to make sure that they subdue those complaints, to make sure that people don't make those complaints and make those claims. It means that for one to be successful in those claims, one has to do something quite distinct. Now, to start with, the first point is that when accidents occurs at the workplace, what people need to do is to report that accident. Now, we have had cases where people have failed to even notify anybody whatsoever on the premises of the accident. So the first thing people need to do, they have to notify the employer of the accidents. But obviously, employers who have 10 or more staff are meant to have accident book on the premises due to the health and safety regulations. And therefore, when there is an accident, you have to insist on recording this in the accident book. Now, when you record this in the accident book, you are meant to obtain copy for your own records. If there is an excuse of not being provided with a copy, you can take that copy with your phone. Because we have had cases where the records have disappeared in the accident book. And people will be wondering, I had this accident, it was duly recorded. Why is it that it's not in the accident book? Yes, sometimes these records do disappear. So when people get these accidents and are recorded in the accident book, they are meant to also have copies. If it is not possible for them to have copies, they could take a snapshot of it on their phone. The second point is that if, for example, you are a worker or an agency worker who have been sent to that premises and you have sustained that injury, you probably will not be able to report it to the manager on site, or perhaps at that point there is no one there whom you can report to. But again, you are also meant to report it to the agency. And very soon, I will let people know why that's so important. So if you are sent there by an agent company to go and work on that premises, you are meant to report to them that you have sustained this accident at the workplace. Now let's look at those who are self-employed. If you are self-employed, then of course, most of these premises by law are required to have health and safety executive. And therefore, if you ever went to the premises and sustained an accident, you are meant to also equally report it to the health and safety executive on site. But when people have reported the accidents, the second most important factor or point that you should also be mindful of is whatever caused their accidents. So if, for example, the door was not well filled and it fell on you, you need to take photograph of that door. If there was water on the floor that was not secured, that you accidentally fell because of that, you need to take photograph of it. If there is a machine there which is defective, that caused your injury, you need to take photograph of it. Why? Because very soon, when people start to make claims, those tools or whatever may have caused those accidents may suddenly disappear. Or it is even possible that the employer was meant to make the workplace quite safe for you, and he didn't. So as soon as the accident occurs, he will probably try to restore or to repair whatever caused that accident. So by the time you are making a claim, that particular block or water that caused that accident will no longer be there. So the second point is for people to also take snapshot of whatever caused their injuries. And in fact, take pictures of their own injuries. So the third point is that you also have to take pictures of your injuries, because you are bringing a case, and obviously some of these cases are hugely contested, and therefore you need to gather your evidence if you want to be successful in some of these claims. The fourth point is that you need to identify a witness. A witness can be a member or staff. It could be somebody who probably works at the same place as an agency worker, or as a self-employed, or as a member of staff just like you, a work colleague. So you need to obviously identify that person as a witness. And if possible, you could even let that person write some note for you to confirm that you witnessed that you had an accident at the workplace, and state the facts, whether or not that accident was not your fault. Because the point is that sometimes, because these witnesses are still working for the employer, when it comes to the point when they are meant to come forward and defend you, they might equally disappear. They might even tell you they are not aware. So right on the onset, when the accident has occurred, that's when you need to do all this information gathering. So these are the four things that people need to take into account when the accident has occurred at the workplace. They need to report it. They need to take pictures of whatever caused their injuries. They need to take their own pictures of their own injuries. They need to also make sure that they identify a witness who might be any member of staff or self-employed person on the premises. So once these four things have been done, then obviously people will be able to contain or maintain this evidence to build their case if they were ever interested in pursuing a case for those injuries. The next thing that is equally important, it is not everybody that will be entitled to a claim. And therefore, when people go to the workplace, they need to also be very vigilant. As I said from the onset, people are only entitled to personal injury claim to the extent that they are able to establish that that accident is as a result of the negligence of the employer, or alternatively, that the employer owes them common law duty, and that duty of care is breached, and their injuries are not too remote from that breach, which means that it is the breach of duty of care that caused their injuries on the premises. What it simply means is that if, for example, there's water on the floor, then obviously, if you didn't notice that there was water on the floor and you fell, then of course, that employer who has a duty to make the workplace safe for you has breached that duty, which is why you fell because of the water on the floor. However, you may also have to explain why you could not see why there was water on the floor. So there is a joint responsibility both on the employer and the employee when some of these claims are being contested. So it's important for people to know that it is not all claims that are going to be successful, because people need to establish that there have been a breach of duty of care. Now, so when there is a breach of duty of care, what then happens? Now, all the things I have just discussed here could lead to two things. Now, obviously, in the UK, if you are sick or you had injury at the workplace, you obviously go off sick for some time. So, the fifth most important point is for people who, for one reason or the other, who have not been able to report the accident to their manager at the workplace, or recorded it in an accident book, or better still, reported it to the health and safety executive, or have been unable to identify a witness. Maybe there was nobody there to witness the accident, or have not been unable to take pictures of these scenes of the accident, then definitely these people can contact their GP as soon as possible. Because some of the accidents might not be so severe enough for ambulance to be called or for an ambulance to attend to the scene. And therefore, when ambulance is not in attendance, and obviously that person has sustained injury. And sometimes when all of us sustain injury, we feel that we are strong, we feel that we are all right, but we need to be checked by a medical expert. So people need to contact their GP. And that contact with the GP serves two purposes. Because one claims, the first purpose is that you receive treatment as a result of the accident from the GP, and you'll be checked. But the most important point when it comes to claim is the fact that this GP will now become your credible witness in the absence of all these witnesses or evidence that I've just enumerated. It means that when your claim is progressing, then of course your medical notes, which has been recorded by the GP, can be relied upon as evidence against your employer to pursue your claim. Why? Because normally when you go to the GP will ask you, what happened to you? You obviously explain to the GP, I was at the workplace, I was climbing the staircase, I didn't know that perhaps there was water on the floor, and as I was climbing, I slipped and fell and sustained injuries. It was just a heavy fall that I probably broke my wrist. So the GP will keep record of all your statements, and the description of the accident will be kept by the GP. And therefore, if, for example, the witness you identify at the workplace decides to betray you because he is under pressure from the employer, or the photograph you took is probably corrupted because your phone damaged. Because these claims take months, if not years. Or probably the accident book has disappeared, just as some of the cases that we do, we find that accident books are disappearing. That of the GP can never disappear. And what I'm discussing here, it might sound so ridiculous. But we are having cases where people, one, they don't report the accident to anyone. They don't even go to GP to talk about it. And some of these people have serious injuries, very serious injuries that can have life-threatening consequence, if not disability. And therefore, it is important that these stuff are not taken for granted. But if you are any of these people who have sustained this accident at the workplace, and you've been through all the stuff that I've just described now, then the next thing is that if you are employed, obviously, as I said, in the UK, you'll probably be entitled to statutory sick pay. Or if you are lucky to have a company who pays company sick pay, then throughout the period that you are sick, you will still be entitled to company sick pay. And some of you probably need your rent paid. So you'll be entitled to what they call either the housing benefit or universal credit. I am saying these things because I've had clients who perhaps don't even know how they should pay their rent. They are admitted in the hospital, but their rent needs to be paid because the landlord needs to pay his or her mortgage. So people need to understand that they have a right to get this statutory sick pay. They have a right to get company sick pay if they have signed up to one. Or they have a right to, obviously, get universal credit or housing benefit, whichever that they should be entitled to. But the question is, what about those who are self-employed? Obviously, they are equally entitled to universal credit, but they will not be entitled to either company sick pay or statutory sick pay. But some of you need to also have insurance in place. You need to purchase an insurance that ensures that you receive payment. So my brothers and sisters who are in the construction industry, look, these stuff are quite serious in nature, and a lot of us take it for granted. It's about time you guys thought about getting insurance to cover you. So the day that you had injury at the workplace, you will have this insurance paying you that compensation. So if you are self-employed and you have insurance in place, then you could also make a claim and get paid by the insurance for your loss of earning or loss of income. So these are what I will call the basic stuff that people are entitled to when accidents occur at the workplace. But coming to the end of my program, I will now look at the main reason why I'm here tonight. And the main reason why I'm here is when you get accident at the workplace, you are not just entitled to the universal credit, you are not just entitled to the company sick pay, you are not just entitled to the statutory sick pay, or if you have an insurance in place, if you're construction, I've already advised you guys to have this insurance in place. for your own protection, so that when you get injured as a self-employed construction worker and cannot go to work and you have a mortgage, you get your loss of earning paid by the insurance company. And last week, I looked at how people could ensure that the insurance companies don't wriggle out of the claim. I gave very substantive advice on how people could avoid not being paid compensation from the insurance companies. But tonight, I'm not looking at insurance per se, but I'm advising self-employed construction workers that probably it is wise to have insurance in place. So when they sustain injuries, even though they will be entitled to make a claim, which I'm soon going to go into, because that is the main reason why I'm here tonight. Having said this, I have said that when the accident occurs at the workplace, first thing is to establish whose fault is it. In most cases, if the employer has failed in its common law duty of care to make the job, the workplace safe for the employee, or to employ competent staff, because any acts of any of the employees, the employer is vicariously liable for those acts if they cause any injury to any of the member of staff. Employer is required to provide equipment, safe equipment. They are required to provide clothing, safe clothing. If it's a construction site, they are probably required to provide some shoes. So if the employer doesn't do, look, if you are doing cleaning, they are supposed to provide you the mop, everything that enables you to do your work safely. You go to some work sites, you go to some workplaces, the employees don't even have the equipment that they require in order to do their work safely. So if as a result of this staff not being in place, and any member of staff sustains injuries, then it could reasonably be argued that that employer has breached its duty of care to the employee. And I've already advised what these employees should do. And I'm choosing my words carefully because I am not just discussing employees, because employees are those who are directly employed by the employer. But there are others who are also called workers. And these workers are probably personnel that have been sent out there by recruitment agency to go and work for that employer. Or probably that person had been sent there as a self-employed contractor. They all have right not to be injured at the workplace. They have that fundamental right enshrined in law. So having discussed what people should do whenever they had this accident at the workplace, one, they should make sure that they report it to, if they are employed, to the manager, whoever is in charge. Two, they should record it in the accident book, because every employer who has 10 or more employees is supposed to have accident book on site. And in fact, those who even have less these days sometimes have this accident book. So they are meant to record it. Three, if you are self-employed, you have to report it to the health and safety executive. 4, you need to take pictures of whatever caused the accident, because that particular machine may disappear in no time by the time you're making your claim. So you should take pictures on your phone, send it to your friends for record keeping. And also, you need to identify a witness. If there is anybody there who saw the accident, probably came to your aid and pulled you from the floor, let him confirm that he has witnessed the accident, if possible, in writing, because that person might deny in no time when it's time for you to pursue your claim. When it becomes so acrimonious, an employer is usually contesting the negligence that caused that accident. I've also said what people normally will be entitled to in terms of getting either company sick pay or statutory sick pay or universal credit or housing benefit, all kinds of those benefits that the states provide, especially for those of you living in the UK. But my main reason for being here is your right to compensation for your injuries. Now, when people have received these benefits, I must say that there is what we call recoupment. Normally, when you are successful in your claim, you hear the word recoupment, which means that if you have claimed state benefit, then you can get paid twice. So when people have received their insurance claims, they've received their statutory sick pay, their universal credit, they are still entitled to a claim called personal injury claim. They are entitled to make a claim for their injuries. So if you ever had an accident at the workplace, it is not just the company sick pay that you're entitled to, or the universal credit because you couldn't pay your rent, or the statutory sick pay. But what are you entitled to? Compensation for your injuries. And most times, when people receive the company sick pay, they are so grateful. And they don't even think of pursuing personal injury claim for the injury they have sustained. Or most times when they receive company sick pay, in fact, some of them are even chased to return to work even when they are not well. And they say don't know that they have a right to claim for their injuries, financial compensation for their injuries. So I want you to understand that when you are injured at the workplace because of accident, you are entitled to financial compensation. And for you to be able to be successful in this financial compensation, I must take you back to what I've already discussed. You need to establish that you are owed a duty at the workplace, and that duty was breached, and it's the breach of that duty of care that caused your accident, which means that your accident is not too remote from the breach. So for example, as I use water on the floor, which is something that normally occurs, sometimes you see people cleaning the floor, they will not put warning sign there. Somebody might not know that there is water, the floor is slippery, and they just walk and just have a fall. That fall at that workplace, obviously because the employer has not made the premises safe for you and you have incurred that accident, or you have been injured because of the employer not making that workplace safe, it means that that employer has breached its duty of care to you, and you are entitled to financial compensation. So when it comes to making claims for your injuries or financial compensation for your injuries, you need to always prove that the employer has done something wrong, or there has been a negligence, or there has been a breach of duty of care. And it is for this reason that I advised previously that you need to keep photographic record of what caused your injuries itself, and also have a witness, because you are soon going to prove that the employer did something wrong or failed in their duty of care. So the employer might not have done something wrong, but they might have failed to do something right. So for example, if there is a machine at a workplace and it's faulty, defective, and the employer fails to repair it, it means they have failed to do something right. Say if that machine causes you an injury, it means that that employer should pay you financial compensation for that injury. And that financial compensation is quite distinct from what I've already discussed, namely company sick pay, universal credit, statutory sick pay. Because soon, viewers will understand the quantum of these compensations and why it is so distinct from those that I've already explained. Now, so under the circumstances, if one has been able to prove that there has been an accident, and from experience when these claims are made, the starting point is getting the employer to admit what they call liability. If the employer admits liability, that means that you cross the first step of your claim. So when the employer admits liability, there might also be what they call contributory negligence. Now, you may have someone working on the premises. They might have given explicit instruction that use this particular machine to do this work. That person might decide that, no, this machine is too heavy. I rather want to use my feet to be scratching the floor. Now, so under the circumstances, if that person refuses to use the machine without good cause, good reason, and rather uses his feet to scratch the floor rather than using the machine to scrap the floor, then perhaps the employer could argue that there has been what they call contributory negligence. So the employer would say that, yes, I accept that perhaps I am liable for the injury, but I also want to argue that the employee contributed to his own injuries. So that's the second point that I want people to be aware of when it comes to pursuing these claims in terms of whether the employer is going to accept liability and to what extent that liability will be, whether there has to be an element of contributory negligence. But thirdly, when these liabilities have been accepted, then there are heads of claims that people are entitled to. Normally, there will be three areas where people can claim. The first element is people's loss of earning. So if, for example, you are paid £4,000 a month, and because you had injury at the workplace, your company doesn't pay you company sick pay, and you only get statutory sick pay of, let's say, about £100 a week, it means that every single month you are probably losing about 3,600. So this might go on for months, and for those of you who may have disability or permanent ailment, it might be for life. So this loss of earning will be calculated, and that's why people should not take these claims for granted. So if it's for 10 months, you are probably looking at about 36. If it's for a year that you've not been able to work, you're looking at probably your loss of earning alone being about 36 to 40,000 pounds. The other point is that you are also entitled to even have your family member to care for you. Now, last time I was explaining this to a family friend, he said, "Oh, that is flawed." I said, "No, it's not flawed. If you had an injury and probably couldn't work, you couldn't clean your house, you couldn't do cooking, then you are entitled to get a family member to do all those stuff for you. And that family member is not going to do it free of charge. Rather, it's going to form part of the element of the claim." And any consequential loss. So let's say, for example, you take a cab to go to the GP. You go for physiotherapy in a cab. Or when you even had the accident, your expensive shoe got damaged. You are entitled to claim all this stuff or costs. But the most important of all is the injury itself. So if your wrist was broken, and probably it might be difficult for you to use it to work in future, then this injury is something that is going to affect your future earnings. So here we are looking at future earning as a result of the injury. We are also looking at the pain that injury is going to cause you. So in this case, the injury itself attracts two elements of claim, which is your future loss of earning and the pain, which could be analyzed and be claimed as cost. But having said this, it means that people don't have to take accidents that occur at the workplace for granted. They are meant to have documentary evidence if they ever intend to pursue a claim. They are meant to ensure that it is not their fault. Otherwise, they will be liable for what they call contributory negligence. And they must report these accidents quite rightly. And if possible, consult their GP and report these accidents so that they are recorded on their medical notes, on their medical record. Sometimes when people get accident, I always advise them, have you consulted your GP? Oh, I'm okay. Yes. That's one distinct thing about accident. You might be okay, but you still need to be checked. Physically, you might be okay, but a shock could also cause you different ailment, so you need to be checked. But the advantage of consulting a GP, as I've already pointed out, is the fact that it allows your record, your statement to be recorded for prosperity. It means that if in future you want to rely on that record to pursue a claim, you have the evidence to rely on. And finally, one will say, how long can I bring a claim against my employer? Or if, for example, I'm no longer working for that employer. You don't have to be working for the employer in order to be able to be successful in your claim. You don't have to. And the good thing is that you have 3 years. So under the Limitation Act 1980, you have 3 years, 3 calendar years to bring your claim. It means that if you had injury in 2019 May, then probably you only have 1 more month to bring a claim. And I have clients who are calling the office and reporting that they had injuries 5 years ago. Yes, of course, that is what they call constructive knowledge. Normally, when it comes to clinical negligence, that is what they call constructive knowledge, because for the clinical negligence, you are not an expert. So you might not probably know whether the doctor who performed the operation, the surgery, had made mistake. But for personal injury, I'm sure perhaps there will be another opportune moment for us to look at clinical negligence. But for tonight, I'm looking at personal injury, accident at the workplace. So you have 3 years. And these 3 calendar years is so significant. Because whether or not you are going to succeed in this claim, you need to bring it within 3 years. If you don't bring it within 3 years, your claim is debarred. It means that whether or not the employer was at fault or failed in his duty of care, you will not be able to bring the claim against that employer. The reason being that 3 years has expired. So tonight I want viewers to know that in all personal injury claims, especially for accident at the workplace, you have 3 years to bring your claim. So please, don't wait until the 4th year or 3.5 years before you start looking for a lawyer to assist you to make your claim. And the good thing is that most of these cases are done no win, no fee basis. Most lawyers deal with these cases no win, no fee basis. And therefore people are able to seek advice if they have ever had some of these accidents at the workplace. And I want to state here that tonight I have just discussed accident at the workplace because it's quite broad. However, there are claims that can also arise when people go to the shop floor, like Tesco or whatever shop floor, any of this mainstream shop floor, anywhere, and one reason or the other, they sustain an injury there. They don't have to be employees. In this case, these claims are brought under what they call the Occupies Liability Act. So if you went to the shop floor, you are a lawful visitor. You are there, obviously, even if you went to do window shopping, you are there for a reason. And you have a right not to be injured whilst you are there. So even though I've looked at the accident at the workplace, there are accidents that are occurring various places And obviously, when those accidents occur, people have right to make a claim. Let's take an example. Those of you who are in the domiciliary care, you go to people's places to perform your duties. Normally, the care company has a duty to ensure that wherever you are going to perform that duty, there has been a risk assessment. There was a time when I had a case where someone just went to perform one of those care duties and sustained quite severe injuries. But of course, as I've already said, it doesn't matter whether you are employed by recruitment company or a care company. That employer has a duty to ensure that wherever you perform your duties is safe and you have right not to be injured. And therefore, if you were sent out there and there was no proper risk assessment, and for that reason you sustain injuries while performing your duties, and that injury is not as a result of your own fault or negligence, then obviously you are entitled to compensation. And I know that most of these companies, they have their insurance. They have their insurance policy because they know that accident is something that normally is unexpected, and that's why it's accident. They can happen. And when they do happen, normally there is a consequence. The consequence is that somebody gets injured and he needs to get paid for the injury. And that's why there are these insurance covering these unexpected events. So tonight it's been very nice having you to discuss your right not to be injured at the workplace. And if you were injured because of accident at the workplace, you are not just entitled to company sick pay or statutory sick pay, but you are also entitled to financial compensation. At this point, our sponsors are prompting me. So I'm going to take a few minutes to obviously discuss what CITI Law Solicitors does, and I'm sure that you'll bear with me whilst I advertise our sponsor who has put me here tonight, obviously to discuss this particular topic tonight. So I'm going to take a few minutes to, I know I started a bit late, but obviously I'm going to just take a few minutes to discuss or to advertise CITI Law Solicitors. Now, CITI Law Solicitors, we specialize in numerous areas of law. We specialize in immigration, employment law, family law, personal injury and clinical negligence, commercial disputes and civil litigation, housing, consumer law, and media and entertainment. Tonight, you can see I'll be here to discuss with you or to advise you on how you can rightfully claim compensation for your injuries if you ever had accident at the workplace. And it's been a privilege having you to join us tonight. So if you ever had any accident that was not your fault, don't go far. CITI Law Solicitors is here to represent you. I'm sure we'll be advising people on numerous areas of the personal injury, including motor accidents. I'm sure I've done tonight I've done accident at the workplace. Maybe another time we'll be looking at motor accidents, what people should do. And because we discussed the insurance, we'll also be looking at it in terms of how people can avoid those claims not being refused by the insurance companies. So if you had accident, other motor accident, workplace accident, clinical negligence, and you want a lawyer to support you, you don't look far. You can come to CITI Law Solicitors, and we'll be prepared to, our team of solicitors will be prepared to support you. Now, immigration, we obviously always make sure that clients get the best outcome, and clients that have been one reason or the other coming to us are aware that we do our best to support them and obviously get the best outcome for them. So if you ever had any immigration problem and or you know someone who has immigration and needs a lawyer to help, CITI Law Solicitors is the best place to be. Now, employment law. Under the employment law, as I always say, most employment cases are done on no win, no fee basis. It means that it's only when the claim is successful, that's when you pay CITI Law Solicitors. If the claim is unsuccessful, we all lose together. So you see, there is a common interest for all of us to win. So if you ever had any of these problems and then you want some assistance regarding unfair dismissal, discrimination, bullying and harassment at the workplace, or you are being made redundant and you need advice on your settlement agreement, we are here to support you. And family law, I always say that CITI Law Solicitors is not just a team of solicitors, we are family law accredited. If you have any family law matter and you need a lawyer to assist you, don't go far. If you are going through divorce and you want a lawyer to help you to secure your best interest in terms of matrimonial assets, we'll be here to fight your corner. If you want to have child arrangement order in place they can have regular contact with your child, we'll be here to support you. If, for example, you are defending non-molestation and occupation order, we are also here to support you. These days, people know that domestic abuse is now criminal offense. Last year, I did quite extensive topic on the Domestic Abuse Act 2020. It's now criminal offense. So sometimes we dealt with a case that the defendant has just been charged and convicted. So people need to be careful. This time, some of these domestic abuse will not just end in the family court, but they will end in the criminal court, and people can be convicted and serve custody sentence. So people need to be careful. But in any event, if you are defending any of these claims, you can see the risks of defending domestic abuse claim or occupation or non-molestation order claim, because, as I've said, it could end up in a criminal court. So they are quite serious stuff that when people sometimes say, I want to do it myself. Yes, it's fine, you can do it yourself. But know that if you make mistake, you could end up in jail. So because family court before, when were the days before the Domestic Abuse Act, that when the matter ends in the family court, you're free to go. This is the family, the court, the case doesn't end in the family court. It might end in a criminal court. In any event, if you have any of these issues and you need proper legal advice, don't go for City Law Solicitors. We are here to assist you. Those of you who have businesses, you want a lawyer to draft shareholder agreement, partnership agreement. If your company, somebody have tarnished your company image and you want a lawyer to respond. If you have trademark, copyright, you want to protect it, you need a lawyer to help you to go through that. Don't go for City Law Solicitors. Is here to assist you. Yes, so these are the stuff that City Law Solicitors does. And if you are looking for City Law Solicitors, you can find City Law Solicitors at Barking. We are not too far from the Barking station. Once you come out of the Barking station, and then you obviously walk past the McDonald's, so the KFC, and turn right, you just find the office there. We will be much willing to meet those of you who need any of these services and willing to allow us to assist them so that they can be successful in some of these claims. So it's been a privilege having you tonight. On Thursday, we are going to have the tree section of the same topic. We'll take our time to explain all these things in tree so that those who understand the tree can equally benefit. And I'm so grateful to you tonight for joining us and for sharing the video. And I thank you so much for your patronage. So it's been a privilege having you. And thank you so much. And God bless you. God bless you.